Well, hello, good evening, everybody. Thanks for joining me. And today we have a little feedback. All right, so tonight we're doing a workshop. So I hope you guys have pen and paper and something, some ice water, tea, coffee, whatever to keep you awake. Not that it'll be boring, it won't be boring at all. But you're not going to want to miss any of this. We're going to move kind of quickly through it. I know 2 hours sounds like a long time, but it's not when you are trying to work through 5 stages of the process. So somebody's laughing at me over here. What's going on?
2 hours?
Oh, I forgot to inform Ron because he would have taken an all-day nap. Okay, so actually he worked all day on annotating another case that he's going to put into the membership site for all of you. So I'm real excited about that. We're going to talk a little bit about that. So tonight, what we are doing is going over 5 stages of the trial process. We labeled these stages, so you won't find them anywhere like this. We did this to help you with organization of your case. So everyone in this tonight, you might be at different stages in your case, and I should be able to see your comments when you put them on here. And you know what, I just noticed I am rotated on the screen, so let me turn my phone. I thought that's why you were laughing. All right, I wonder why Ron says I'm always doing somersaults on this thing. Thanks, Kendra, for letting me know I was sideways. I thought you were just talking about me in general. Okay, is that better? So if you guys don't have something to write on, use your computer, phone, notepad, whatever you need to use. Sorry about the glare with the glasses. Not a whole lot I can do in the evenings. Kind of keep my head tilted down so it's not as annoying. So let's go over. Let me move my stuff here so I can see your chats. There we go. Let's go over first how many of you are actually in the trial process right now. So if you're in the trial process right now, put yes, just so I know how many we're dealing with in trial process or appeal, so I know how much time to spend on each one in this. So in order to put this all into perspective, first let's take a look at the whole process so you can understand, and then I'll go back to each stage and we're going to cover a little bit in each stage, right? We're going to go over where to use your arguments. You have to make arguments throughout this, and we're going to talk about that. You have to make the arguments in your written pleadings, in your trial, and then there are ways that you have to preserve them on top of that. They try to make it as difficult as possible for you to protect your rights so that they can just do whatever they want to do. But you can't appeal if you don't follow these rules. So we're going to talk about that too, where to find the rules, and why it's so important to go over those and know those. I know it sounds ridiculous how technical they are, and it is wrong. They should be just protecting these without you having to do all of this and go through all of this effort, but they aren't, so you need to, okay? And I'll give you an idea. After this entire court process, you're going to spend another several hundreds of hours putting together an appeal. So the more organized you are at this trial process, the easier it's going to be for you to go through the appellate process. Now, that's assuming you don't get what you need to get in the trial process. A lot of attorneys will tell parents, we don't want you using these arguments or doing this way because you're just setting up for appeal. You're signaling to the judge that you're going to lose. That's not true at all. If the judge is going to think those things, they were probably already against you anyways, or they absolutely were not applying protections to your rights if they were proceeding in that way, all the more reason you need this. But also, there have been plenty of parents who have made progress with this. They have gotten time back with their children. I've said this over and over again in lots of webinars that we do. They got supervised visitations canceled by doing quash orders. They got and those are a type of protective order. We'll talk about that. They canceled. They got supervised visitations canceled. Let me correct my language there. And they've people have gotten the case to go back to their original final orders. Now, if you don't want that, so you got to pay attention to what you ask for. If you don't want things to go back to your original final orders, then of course you're gonna not do that, right? So you can pick and choose out of these procedures that we're going to go over which ones you want to do according to what you're trying to achieve, right? So don't just I'm going to have you write them down, but don't just do every single one blindly. Okay, pay attention to what each one accomplishes. All right, so the reason you have to do all this in the trial process is because they can't make a mistake if you didn't give them opportunity to rule on it, right? Okay, I know you guys can argue they're making a mistake by not applying your constitutional rights protections. That is true, but like I said, it's not how they're doing it, so you have to do it this way, okay? Appeals are for arguing error, so you have to, what we call, force the error, okay? And especially since they're denying protection of these rights, you have to assert and raise the rights. And even though it's their duty, you have to remind them that it's their duty and you're going to have to do some extra work to do that. So you have a lot of bad, terrible, actually, precedent to overcome. All of you guys do in all of the states. Some states it's worse than others. So first, let's introduce you to the 5 labels of the stages of litigation, essentially the court process. Okay, so before you can learn to navigate it, you have to know what it is. And I always like starting with the end so that you have a better understanding of what you're about to face. And that's something I wasn't provided with when I went through it, and it would have been extremely helpful. And I'm looking down at the computer, you guys, because I'm checking your comments just to make sure you're following along. You got everything. I think we've got everyone here who's coming. So how many of you would have done things differently if you had known what you know now? So just put yes or no if you would have done it differently if you knew the things that you knew now. Now that's not counting tonight in the workshop, but just in general, what you've been through. Okay, so I see one says absolutely, another says yes. And by the way, you guys, it's limited people. There are limited people in here. You're not going to see a ton of people. When I first do a workshop, this is like, I hate to say, like my, your initial run. It lets me know what I want to change or what I need to time differently. So I allow my members to come in. And so you guys get the benefit of that, but you also get to work through the process with me on the delivery. So you can always give me suggestions later. But also keep in mind, your ex could be in here. So anything you say on here or anything you do in writing, they can try to use it against you. So even though you're learning your rights, we don't want you to make it harder on yourself than you need to. So be very mindful of how you're exercising those rights in here. If there's something you want me to see in private, send it to me, either private message or send it to me on email, and just let me know that, you know, you're sending it private regarding the workshop. Okay, so make sure that you're writing your questions down as well, because as I go through this, I might not be answering your questions right away. We will get to as many as we can at the end, but write them down. I don't want you to forget them. And then we'll get to individual questions that aren't related to this another time. So if you want me to consider something for a blog or a topic another time, also email that to me, okay? So let's break the court process down. So get ready to write these 5 stages, as I don't have them in a PowerPoint or anything for you right now. Stage 1 is the initial filing stage and your standing orders. Okay, so most states have standing orders. You either got served or the other party served you, and that is stage 1. Stage 2 is discovery, and if I go too fast for you to write it, just let me know and I'll slow down as much as I can. I don't want to go too slow so we can cover everything. Stage 2 is discovery and preparation and build up to the final trial. So it's all the middle part of the process up to the final trial. Stage 3 is the final trial itself. Stage 4 is post-trial, and we'll talk about that. That's motions you file after the final trial is complete. So believe it or not, we consider it a whole nother litigation phase. Stage 5 is your appeal. Okay, so let's go into stage 1 in more detail. Most of you are past that stage 1. Okay, I don't think any of you are in here who are considering divorce or separation, or maybe trying to establish paternity and nothing's been filed yet, right? If you are, let me know. If there's no litigation in yours at all, even if you're just in mediation, then just say no litigation. So I know that you have an opportunity to frame your case up and not have to try to undo something that's already been done. Okay. Hold on here. Camera got bumped. Are you? I guess our power is giving fits to us right now, but it's not affecting us directly right now, so we should be okay. All right. Let me try to get this fixed. Sorry about that. Okay, so someone says they're starting a new custody case. Okay, so if that's a new custody case, then what you're talking about is a modification, right? Just tell me yes or no if that's correct. And I don't know if I'm going to be able to get this to work again here. Something bumped it. Hold on, guys. Okay, so if it's a new custody case, are you meaning there's no orders, or are you meaning that it is a modification? So just say what you mean down there. I'll get this to just where I want it to. Okay. So phase 1, you have your trial court, and you might be in an administrative court, you might be in a magistrate's court, you might be in a Title 4D court if it was initiated by your Attorney General. Okay, and I see the yes there. You might be in district court, superior court. So just type the type of court that you're in on your notes. So we have that. Okay. So whatever label your court is, that could be important as well, because there is a specific process and procedure for each of those courts, right? So you're going to have your court specific orders, and then you're going to have local orders for the actual entire court building, I guess is what you might call it. So you've got your particular judge that's setting those orders, or administrative, whatever they're called, magistrate, and whatever their rules are. And then you've got your local rules, and then you have your rules of civil procedure, right? And what we're integrating are your constitutional, the federal rules that say that you have specific rights in the due process part of it. So equal protection, due process, all of those. Some states, many states have incorporated that into their constitution, right? And some of them are more protective than the Constitution, but most of them aren't applying that either. They kind of pick and choose what they're applying. So in the whole course that we've done with this, navigating the court process, we'll go into more details on that. Since the time is limited on this workshop, we're going to touch on certain things, delve into a couple things a little bit, but again, like I said, it's only 2 hours. So I'm giving you basically the whole organization of it. So then you'll know when you take the entire course, which pieces are most meaningful for you, depending on what stage you're in. And we are going to break those videos down into sections. So if you do need to skip some, you can. Okay.
And it may not
Ron's over here, by the way. You have to come in.
And it may not be absolutely technically correct as she's presenting it, but I'm not going to chime in unless it's just egregious, and that'll be in the core course that you can look at the specifics and, the details that I might otherwise correct.
Technically correct.
Just kind of the structure of the procedures and the difference between the federal and the state. Not a big deal for the webinar, but you need to understand it precisely when we get into the course.
Yeah. Okay. So that part, yes, I agree with. I'm just giving you an idea of the kinds of rules you're going to need to know and look for. I'm not really, I wasn't really putting the structure of it together. Ron is super technical. He does the majority of the technical stuff. I help you guys with the organization. So he is here and he is going to chime in on some of those things. Okay, so you've got the idea down that you're going to need to know all those different rules. So I want to ask, how many of you guys looked up your judge online to find out what your judge's history was in how they rule? If you haven't, you need to write down to do that. How many of you have looked up your opposing counsel, the other side's attorney? How many have you looked up? Okay, so one of you just got a new judge. How many of you have looked up their records on appeal? So one thing that can really help you is, yes, excellent, Kendra. You look up opposing counsel, look at their website, look at what they say their strengths are, look and see if they are bragging about any kinds of cases that they've done. Look those cases up, see if you can find oral argument done by them. See if you can find briefs that they've written, trial briefs even. Sometimes trials warrant trial briefs. If you have to, go to the court and pull some of that up from other cases and look through what they're filing, what kind of claims they're making. The reason you want to do this is it's going to give you a picture. This is a playbook, right? So it's like you're getting intel on the other side, which is the other side that's attacking you. Do the same thing if they've appointed a guardian ad litem, and we haven't gotten to that part yet. So the first stage when you first get filed or get served on or you file is gathering as much intel as you can, and then we'll learn to lace in the constitutional arguments. And this, so don't worry yet where you add in the constitutional arguments, because I'm going to presume that everyone watching this right now doesn't know them yet. Now, most of you remember, all of you are members, most, and so you have access to the Protecting Family Rights course, and you have access to the Green Book, which, by the way, I'm going to start doing some workshops on those, breaking those down to make sure that you're all learning, processing, and learning how to articulate those in relation to your particular circumstances, right? So we've been getting briefs back from parents who are writing like either trial briefs, motions, things like that from some of our members, and that shows us the way you have processed the information we've provided to you and how you're arguing it. It allows us to start adjusting how you're making that argument. So for instance, we had one parent who argued the Matthews test throughout the trial, and then argued it in the appeal, and that's when I noticed there needs to be a few tweaks to happen there. One, for instance, was where the parents cited the test from, the three-pronged test. Okay, so you might not always be going back to the original source to reference for your particular case. So the one I'm talking about right now, and we won't go into a lot of detail, but it's Matthews versus Eldridge. All of you need to be applying this, and if you don't have the motions package, then you should be reading those motions in the membership site and making sure that you have that as your basic foundation argument down. and know how to integrate it. If you're not doing that from the very, very beginning, then you're framing your case the way the attorney has framed it, which is each side is deferring to the judge, asking for the judge to determine best interest. And you're giving that judge carte blanche to redistribute your rights. So if that's what you've done, you need to change it immediately if you have not gotten to a final trial. And that means you're going to have to put a lot of this in writing, which will give you good practice. But then what I'd like all of you to do who have attended today is take just that one piece. So write this down as your homework, Matthews versus Eldridge. And I want you to make a short video for me and send that to me. I think you'll be able to email a link to me so you can, if you have a YouTube channel, upload it private and just send me the link so that I can hear how you are adapting, like how you're understanding the Matthews test applies to you. So take some of your case specifics. So if you are, if the other side is saying that they want you to be restricted to a part-time parent, and they want to put you on standard visitation for Texas. Other states, they may call it standard as well. Some states is 4 days a month. I want you to apply the Matthews versus Eldridge test the way we taught it in our courses. So if you didn't watch it yet, then you're going to have to ask me to get Ron to try to help you find where it's at in his course, because I want you to do this very quickly. I want you to articulate for me in a video, no more than 2 minutes, please. It should not take you more than 2 minutes, so I can hear how you are going to argue that to your attorney, so you can teach that attorney how to argue it for you, or how you're going to argue it to your judge, because you might be self-represented or pro se. That is the very first most important thing you guys need to learn, okay? Because that's where you're going to put that limitation, or you're going to tell that court there are limitations on their power and their authority, and it's not really set by you, it is set by the Constitution. And you have to articulate it in a way that they can take action on it. Okay, that's a big mistake. We're pointing out pitfalls, so write this pitfall down so you avoid it. It is parents many times ask the court for things the court cannot give them. So you need to ask the court for relief the court can provide. So what you're trying to do is position yourself to say that the relief the opposing counsel, the other parent is asking for, is not allowed to be provided by the court. The court cannot give it to them. All right. So let's see where we are. Okay. So how do you get this in if you've already filed petitions, or if you were served, you filed a counter petition? How do you get these arguments in there? Well, you're either going to be able to amend your petition, or you're going to have to file an additional petition or motion. So you'll have to look it up in your rules and see if you have an avenue to do that. If you don't, that's when we look towards the declaratory judgment motions. Now, those have turned out to be very technical for people. We have had attorneys file the motions complete in their entirety, just like Ron wrote them. Then they have to know how to keep them alive, and that's where the problem has been, because attorneys haven't gotten this kind of training. We have worked with some very smart attorneys who really want this to work and help the parents, but they're having difficulty keeping those alive. But let me tell you something, you guys. The point isn't that you're necessarily gonna get that court to apply things that they've never used before. The point is you are trying to force errors. So if those motions do get denied, you just need to know how to preserve them properly. Okay, so don't stress over the fact that, oh my gosh, I failed. They said no, they didn't apply them, all is lost. No, a lot of times attorneys have a difficult time with this because they like winning every battle. But smart attorneys know you don't. You don't win every battle. You can lose every battle and still win the war, can't you? Vietnam did it. They proved that. So don't stress over that denial. Just make sure you're learning from our system how to keep that assertion that applies to your case, that those tests and that you were asking what processes do. And that's another term I'm throwing at you. So now you've got what processes do. You need to note down for your homework. You need to learn what that is. And the Matthews versus Eldridge test. Two things that you are going to continue to assert in your case to preserve these arguments if the court doesn't do the right thing for you. Okay, so if you can't amend, then you're going to have to look to the declaratory judgments. We have been calling it pretrial motion. We like the pretrial motion because that is the most recent rendition. What Ron did is summarized those 3 big declaratory judgment motions, so he really likes that one. It's a lot tighter and simpler. He's considering writing those declaratory judgment motions into like little mini trial briefs for all of you. So that takes time though, so it's not there yet, but the pretrial motion is really good, really solid. So if you need a little help with adjusting or tweaking that stuff, you can always send customer service an email, ask for that service if you can't do it all. So we do expect all of you to put effort into this because you're the ones on the hot seat in the court. You are the ones that have to ultimately be your own mouthpiece. We are just here to help you learn it as best you can. And don't worry, you don't get it perfect. Okay, that's fine. Just presenting any of it at all is going to send the right message and at least preserve something. Okay. So let's go on to the next thing. Why did we do all of this? We did all of this so that, because your attorney's going to ask this too, so that they cannot deny your rights arguments and so that you're providing notice to the court that these arguments are part of your framing. Now, the reason that's important is if you go and you look up appellate case law, you will notice that most of the time the appeals court will ignore the constitutional rights arguments because the entire case was framed under best interest standards and framed the same way they've been doing it for decades. So their status quo was maintained, let's say, throughout your original final trial. For those of you who already have an original final trial and you're in modification or considering it, what they do is they go back and they look at what were those orders premised on. So right now, if you're not in a final and you just have temporary orders, they go back and they look at that. What we call that is a pattern. Your judge is going to follow a pattern. And you've set a pattern according to the way you argued to get the first order. So it takes a little while to turn that around. It took me a long time to get my court out of that pattern and to recognize that I had reframed my cases. Man, they kick and scream and they do not want to recognize that you've changed it. So you have to be patient with that, but be persistent as I was, and it causes you to be caught in lots of circumstances because you have lots of little interim hearings, status conferences in some states. Sometimes it's just you're trying to get a something additional in a temporary order. But regardless, if you look at docket sheets, you've got tons and tons and tons of activity on your cases, little mini type of bench hearings, as they call them, where you don't really have any witness testimony. It's just the opposing counsel, your attorney or you, and the opposing counsel going up asking the judge for something, right? There may be a trip planned and you need something done with the children's passports, things like that. You're going to encounter lots and lots of circumstances where you're going to have to tell the other side and the judge no. Which brings me to the second segment. So save that. That's going to be related to discovery about your no's and what you're authorizing, what you're not, what you're resisting, what you're not. So you have to protect your rights through the pendency of your case. This is why we did this. During the time that you're waiting for your case to go to final trial, there's going to be a lot of plays that happen, a lot of tactics used to cheat you out of these protections. to deny you even the basic protections of the rules of civil procedure. Some of you don't even get hearings on some things. They're told to wait outside, and they make decisions for you and come out and say, here's a new temporary order. Happened to me. Take for instance, let's see, on an appeal, one of the appeals that I was just going over last night, one of them didn't even get the benefit of the civil rules of procedure. Oh, that wasn't last night, because I brought this one up. That was a couple weeks ago or so. They said in the appeal that one of the rules wasn't applied from the rules of civil procedure because the parents' side that was arguing it on appeal as being error because they didn't apply it, they didn't ask for it. So if your attorney doesn't know this, or you don't know these technical procedures, these can catch you. This is why I say look up appeals, look up the names. You can look up appeals, like you can do searches on scholar.google.com, and you can put in the other side's attorney's name. That's how you find appeals that they've been on. You can put in your own attorney's name. You can put in your judge's name as a search term, and it'll pull those up, all appeals involving your judge. You can put in the number of the rule or the statute that you're challenging, and you can find appeals on that and find what appellate courts have decided. Now keep this in mind. Just because an appellate court has decided best interest is constitutional or something else is okay, it does not mean that you just buy that and you just go with it, because they most likely did not argue First Amendment rights arguments. They probably didn't have the same facts and specifics as in your case. I was actually looking at a case last night where the appellate court in, I want to say it's New Jersey, was arguing that they did not have to apply certain rights protections for certain reasons, and if you know those in advance, and I'm not giving you certain details because I don't want to get caught up in that, if you know those arguments in advance, and what they're saying you're entitled to and what you're not, then you know how to position your case, right? Because you know you're going to encounter that. You know your judge is probably following that precedent, so that's what you're challenging. And so you have to make it very, very clear that that's what you're challenging. Could even bring that case up and say that this is why it doesn't apply to me. One thing I will bring up, they said in New Jersey, is that they do look at every case as a fact-specific individual case, and they were saying, so I'm going to tell you a little bit about it because it pissed me off so much. They're saying that they have to have flexibility, and there should not be any bright line rule or any standard law that they have to apply, right? They did not want any bright line rules to apply to family court, because they said, oh, judge has to have flexibility in order to fashion the relief packages that they need to fashion. It was a paternity case, and they are very, very, very sorely wrong when it comes to constitutional standards, the basic due process standards that we're talking about. You don't get to just decide you don't want to apply them because, oh, it might not let me provide the relief I'm trying to provide. That's not the way it works. That's how they're actually undermining your rights and harming your children, harming you, is because of that thinking. So anyone in New Jersey is facing that, and you have to challenge that type of thinking. That's what I meant by bad precedents, okay? So before we go any further, I want to let you guys know that most of you do know, but for people who aren't going to be members who might get to see this, I'm Sherry Palmer. That was Ron Palmer you heard earlier. We're with Fixed Family Courts. We write books about the technical applications of the constitutional rights, also education about what your rights are and how we believe they're applied according to the way we interpret them from case law. Okay, so we don't make it up, although we do have epiphanies and we do make breakthroughs, like we find things that are hidden, like applying Matthews versus Eldridge. So Ron is an expert in identifying areas that have allowed errors to happen, I guess, for lack of better words, right? He used to do this very high level in organizational, very like
Systems consultant and
like
Fortune.
Fortune 5 companies. He dealt with CEOs, COOs, CFOs, CTOs, CIOs on identifying organizationally where they had problems and what solutions to apply to those. And that's what we're doing in family law. So that's who we are. We are not attorneys. We don't practice law. We're not a substitute for an attorney. We cannot represent any of you. We cannot speak for any of you. But because you're all members, we can help each other, right? We can all help you. We can work with you guys and make sure that you are getting this to an effective application. Okay, so while we can't fill out forms for you, we can help you be as effective as possible, right? We're going to be teaching different segments of the course, by the way, too, so you'll see both of us in different videos. And I might cut you short on something tonight if I start addressing it. It's not because it's not important, it's just because we have little time. If I tell you it's a question outside of here, you guys remember what to do. Send me an email, okay? If you're a member, you know you have a special email you can email me on, and I'll give that to you all later. So we're going to move into stage 2, and I see you're all writing here. Okay, I see your questions there. We'll get to those in a little bit. As long as you're all still with me, we're good. Stage 2, in more detail. What did I tell you stage 2 was? It was everything in between before your final trial, right? So it's discovery. It is, and you want to note down all the different types of discovery that you're facing right now. And by the way, something I didn't mention, and this is where it becomes relevant here. You want to make sure that if you don't have one now, or if you can't afford to get one, go to your local law library and get a family law practice manual and read through it. I know it's work. I know you didn't intend to become a lawyer in all of this, but you do need to know these things. These laws and these procedures are what is going to affect either the next several years of your life, next decade or so, depending on the age of your children, perhaps for the rest of your life, because there could be permanent alimony, spousal maintenance, things like that involved. So you need to learn this as if you were a student of the law. You're going to take some shortcuts in it because, of course, you don't have as much time as a lawyer did. They've studied for 3 years, although many cases go on for more than 3 years. Some people I know have been in it for 12. So you get one of those books, or just read as much as you can when you visit the law library. Also, you need to get a book on discovery. You need to get a book on the most common objections. So note these down. So you want the Family Law Practice Manual, a book on discovery. Yes, they are state specific. Someone asked that question. And then you want a book on evidence, entering evidence. So it's just get a general book on evidence, because it's going to have all kinds of things in there that's going to also teach you about things like, well, your book on objections and evidence are both going to teach you about different legal terms that you'll need to know, like hearsay, and what is de novo and plenary, and that'll be in your practice manual. So all these books are going to give you legal terms that you're going to need to know and you'll need to understand so that you can continue to be the guidance in your case. If you just let an attorney run with this, you're not going to understand certain things. You're going to get frustrated, and everything that you ask for in this stage 2 of this case is going to cost you money. Stage 2 is usually when they have gals come into it. Now, I'm not saying it can't happen in stage 1, but generally I was considering stage 1 just the filing, the initial filings. Okay, some standing orders may have certain things in it that some states don't. In Denton, in Dallas area, Texas, they don't have gals appointed, things like that in their initial filings. So, but some people do ask for them, and you get very quickly they'll go to a temporary orders hearing. So you may have that in stage 1. But stage 2 generally is where a gal is appointed, or an amicus, but we're going to focus more on gals, because they seem to be the most common. That's a guardian ad litem, and they can cost a lot of money for the states who aren't paying for them for you, and the court can decide that each side pays an unequal amount, like you might be held to 75% and paying for the gal, and the other side 25%, or it might be 50-50, but it can still go crazy. Most states don't have caps on how much a gal can charge you. And so general discovery, so you want to note down general discovery and what is in general discovery after you've noted down what books that you wanted to get. And I know I'm kind of jumping around, so just note these down like brainstorm. Then you also want to put that you need a helper. So you need like an advocate or paralegal, legal secretary. There are some online now, like paralegals, legal secretaries that you can get to help you with things that cost less than utilizing an attorney. You need somebody that you can go to in times of crunch. Like sometimes ex parte orders are filed during this interim time. Remember I said that they're going to use a lot of tactics and make a lot of plays. So they're going to do things like that, and you won't always have time to be the one to respond. So you need that person now before you need them. Does that make sense to all of you? You need to know you have a number that you can call and that they're available. Say, oh my God, there's an ex parte filed. I need a motion responding to it immediately, or I need some kind of lesson from you. What do I expect? What do I need to look at? What is my defense? Where are those rules? Where are those statutes? So even if you read through things generally, you guys, it's very overwhelming. This is just to prime your brain to read through things generally. But then you're going to need somebody that can kind of help you pull those out, right? We do that with the constitutional arguments. We don't do that with all the general rules. A lot of times it's the technical general rules and procedures that bite parents that get you, is the technical procedures. Okay, so you need all of that. So what's part of your general discovery? So write down general discovery. That would be interrogatories and depositions. Can you think of anything else? Comment down below if you can think of something else they used in discovery. So they may ask for your financials, right? So you might have to do a financial affidavit. They could ask you for to respond to, there's all different labels that they use. So we said interrogatories, which you are limited to a certain number of questions for interrogatories. Phone records, okay, true. So there's lots of things they can ask you to give them, and they can get you caught up in a lot of busy work, a lot of stuff that perhaps you don't need to be doing, but how would you know if you haven't read the rules, right? So I get a lot of parents who are in this stage who are frustrated, who say, I just absolutely said, no, I'm not giving you my financials. It's usually financials that really people get irritated about, especially if they were never married to the other parent, and here they are now wanting to know everything about their business, and maybe they were never even really together, right? Maybe they never even really lived together. And here they're having to open up their life like an open book. So this is where it's super important that you know the rules, because there are some things that if you deny can bite you in the butt, right? The judge in these civil cases will say, and a lot of times the statutes do say this, so if you read it, you would know that they can assume that you're guilty of something when you refuse to produce it. So if you do not know to fight that or know how to fight that, that can come back and bite you in the butt, and can come back and be used against you, not just in your trial, but then when you think, aha, I got you, I didn't consent, so now I'm going to get you on appeal, the appellate court can turn around and say the exact same thing, like, oh, you caused that loss on yourself. So you need to know what the rule says, what a proper defense is for it if you're going to refuse to provide it, and if you disagree with the statute, what your challenge is, and if there's a constitutional defense on it, you need to know how to articulate that inside and out and be able to articulate case law that backs it up. All right, and that's another thing you'll learn in this entire course, not this workshop tonight, is about case law and authorities and applying those. And that's why Ron is annotating case law, so all of you can understand it better and how we're applying it according to these rights that we're talking about. So one of those rights in your discovery portion is your right to refuse exploratory searches. And what do they do when they bring gals in is they pretty much, the statutes give them carte blanche. I know I've mentioned Ohio statute to all of you, and there was an actual order that I read that said this gal just had, your life was an open book to this gal, period, and that you didn't have the right to refuse. So if you were going to challenge that statute, you would need to know your constitutional arguments very, very well, wouldn't you? Because of course the appellate courts are going to uphold it unless somebody argues that it violates some right that they had, and that right is you have a right to be free from exploratory searches. They're digging up things to try and use them against you. And in civil, unfortunately, you don't have the same defense that you have in criminal. You want to give? Oh, he can't even hear me over here, Ron. Okay. So I was just explaining to them the exploratory search part and that they had a right to be free from exploratory searches. Do you want to give a little input on how that's articulated a little more with the constitutional argument?
Right.
Like when they bring a gal in and say their life's an open book.
Right. So the Fourth Amendment is very clear that you can only conduct searches that are particularized. That means that they say exactly what's to be searched and what's to be seized. Right. And the Fourth Amendment was written specifically to counter exploratory searches conducted by the British government, where they would just come in and look for reasons to get you, right? And so it was specifically written to prohibit that. And so any order to search is a search order or a search warrant by a judge. It's just, doesn't matter what they call it, it's still a search warrant. And it has to be narrow and particularized, right? And if it's not, then it is illegal. It's as simple as that. There is no justification for an exploratory search ever in our Constitution. It just cannot exist. So when they say we're going to send you to a psychological study, right, or whatever they label it, family studies, 409,
Social
709,
studies.
whatever the numbers are for those things. In California, there's a number, 709 or something like that.
I think it's 730s.
730s,
Yeah.
whatever they call them. Those are searches. They are searching through your personal life, compelling you to provide information to them that they can use against you. That is absolutely unconstitutional. It's also compelled speech, so it violates the First Amendment. It's also a seizure because you are not free to leave. If the judge orders you to go and talk to a psychiatrist, psychologist, whoever they are, then you are seized. You are not free to leave. That is a seizure order.
And if you don't, they use it against you and say you're hiding something.
Exactly.
So
and these attorneys, they just go along with this garbage like they've never even read the Constitution. It's mind-boggling how pathetically inept these attorneys are in family law, or how unwilling they are to confront the judges.
And if you look at the case law, like I was doing last night in New Jersey, where they're saying, no, we don't want any of these rules. We don't want to have restrictions put on us, because then we can't, because every person, here's what they said, every family is not similarly situated. And I believe they're misinterpreting similarly situated,
well,
by the
that
way.
doesn't even apply.
Mm-hmm.
That's just a nonsensical argument. Article 6 of the United States Constitution includes the Supremacy Clause. It says that the Constitution is the supreme law of the land, no matter what any state statute or any state constitution says to the contrary. And it requires every single judge in this country to swear an oath to support that Supremacy Clause and to support the Constitution. When those judges say that, they are flat out violating their oaths. They are telling you their word means nothing.
Right. And so the issue becomes a checks and balance system problem. As you all know, if you try to go and report the judge, like do a recusal, you end up with another judge doing the same thing. Or if you try to report the attorneys, You do a complaint on them. It's the attorneys reviewing the attorneys. So unless it's something straight up like, hey, they took my money, didn't provide service, if you're complaining that they're not providing, you know, the representation that you believe you're entitled to, which is protection of your rights, they will just throw that out and ignore it. So there's no checks and balances left. So you are the one who has to become this check and balance system. And that's exactly what we're trying to do, is transform you into being that checks and balance, so that we, the people in the Constitution, that is exactly what that's for. Civil rights movements, that is what they are about. That's civil rights movements push for checks and balances, because that's how we protect our rights. Okay, that's why our founding fathers have 3 different branches of government. That's a check and balance system. But there are times when things don't work the way they should, but that's why we have these corrective measures. We are, as Americans, allowed to rise up, assert our rights, resist government abuses. Yes, you can take some abuses for doing it. Okay, so someone's answering Robert. I'll get to you guys in a minute. Someone just said Robert wasn't accurate on something. I'll look at it. We have to be careful how we articulate things. Like Ron said, he'll pick on me, and it's welcomed, because you do want to improve the way you are articulating. You got to be technically precise in legal situations. And then you want to bounce it off a lawyer, because they do know technical precision. They spent a lot of years in a law school learning that. So once you present it to them, the majority of the ones, once we've presented these arguments to them, they do get it. They just say, you've got a lot of bad precedent to work through. So as long as you're willing to do that, in my opinion, we all don't really have a choice, right? They are taking the children. They're separating you from your children. I don't know what choice you have, right? Other than you have to do this. So it's either walk away or you do this. And a lot of times people don't even have that option. Walking away isn't an option. You're going to be sunk so deep into debt. They're going to take so much advantage of you and put on as much financial burden on you as possible. Even if you didn't fight these things, we see people with child support orders that go beyond anything they ever earned. We see spousal maintenance or alimony orders that went beyond what they'll ever be able to pay. So even when you don't do these things, so they've forced this type of response out of all of you. So don't feel bad for 1 second that you are having to do this, right? I don't know how many of you have actually sat down and had time to think about what it is that you're actually doing and why and what it's accomplishing. But this is the way we get our rights respected, right? We just didn't think that we were going to have to do it like this in family law. We thought our rights, our parental rights, were protected, and we were all wrong. They are protected higher up from the Supreme Court. It just hasn't translated down to the state. The states have their own ways of doing things, and the federal courts for so long have left the states alone because of this little thing called comity, right? So they said, you know, we're going to let you do what you need to do with domestic relations cases. So we won't go into all of that. We do in the course, but that's part of the reason you're having so much trouble, is because the states no longer feel like anyone's going to do anything to them. But you are. All right, so stage 2, go to your local library if you can't find stuff to answer your questions. A lot of times attorneys will answer some of them, but some of you can't afford it, so you got to go to that paralegal or the law library and get your information. So to summarize, your rights arguments being put into stage 2, into your pleadings, like amending your pleadings or adapting pleadings, provides notice to the opposing counsel and the court that you're going to reframe your case. You're going to switch the burdens back over to them, and the other party that's asking the court to infringe your rights. And if you want to see a really, really good oral argument, I know it's an appeal, but remember the appeals had to make arguments after they made them in trial. So it's In re Sanders. I know I brought this up over the years. We've been bringing this up since about 2014, I believe. And it's a beautiful oral argument made by Vivek Sankaran. And if you listen to the way he takes charge from opposing counsel, which is the state is trying to take over the rights to this little boy because this father has been incarcerated and is going to be in federal prison for 5 or 7 years. And they felt like it was a hands down slam dunk. They acted like the other side was ridiculous for even taking it to the Michigan Supreme Court. And by the way, this is how you get treated in your trial, right? They treat you like you're dirt. How could you even fight against them when they're looking after the best interests of the child? Don't believe that lie. They're not. They're looking after the best interests of the state. So that oral argument will show you how to take control. Every time the prosecutor took over and tried to take control, Vivek would come back at them and say, no, court, that is not what I believe this court should be. That's not the question I believe this court should be answering. And that's what you have to do in your trial court, is you got to do the same thing. You got to take back over, because if you notice, if you're a pro se or self-represented litigant, the other side will try to talk most of the time, and the court will even defer to them. And you're going to have to push that court and say, Judge, no, I get a turn to talk. You ask them, now ask me what my solution is, right? Or ask me what I believe we're here for today. You've got to push that. I did it, and it worked, okay? It works to reframe that. And if they provide a solution, you provide a solution, all right? If they provide information about a particular issue, you provide information about a particular issue. That is your chance to frame it back into the way you want the court to respond. That's why the other attorneys do that. That's why they want to talk most of the time. Okay, so stage 3. There's lots more in stage 2, but that's all that we have time for on that. Stage 3, you want to note down, is final trial. So that's going to involve testimony, witnesses, challenging court-appointed reports, preserving error on the record, court reporters. You need to make sure you understand court reporters, their role, whether or not you'll have one. It's very, very important. You cannot preserve a record without a court reporter. You will make objections. You need to make sure you got rulings on your objections. If you still have outstanding motions that didn't get rulings, we've gone through appeals where they say you didn't get a ruling, or because your motion was denied, that argument is gone. So you're going to have to know the way it's handled on appeal there, so you can make sure you get the right thing on the record. Cross-examination, you're going to need to understand the purpose of cross-examination. It's not going to be what you think. You always think cross-examination is about, or you might think that cross-examination is just about getting more information out of that purpose or that person, but it's not really. You don't really care about how they're responding. What you're doing, because you can do leading questions on it, and I'm giving you these little tidbits just so you understand, because I don't know how close some of you are to hearings or finals. Cross-examination is where you can use the other person's words for framing what you're asking the court to do. You can do leading questions that you can't do on direct examination. So think about that. You can continue to frame the case the way you want and use the other person's words. You don't care what their answers are. You're basically creating a narrative to the court there. So if you watch attorneys, a lot of times they're talking over the person that they're asking questions to. They don't really care what they say. They go on to another question that's completely not related, but it allows them to talk about themselves, to talk about their client, right? Have you heard them do that? That's what they're doing. That's why I'm telling you, this course that we're teaching, Navigating the Court Process, is beautiful to help parents feel like you've been submersed in this, you've gone through it, and when you actually see it happening in the court, you understand it and you know how to respond, right? It's just something that I wish we had a long time ago, like when I went through it, because I would have understood so much more. I wouldn't have been so panicked. It wouldn't have sent me into anxiety and depressions. I think by being able to control your emotions and those frustrations, you're going to be more successful right there. Just with that, if nothing else, that will help you make better decisions and present better in the court. I've actually had attorneys say parents have presented better because we were working with them. And this is why we teach them what this means, what this is all about. So how many of you are familiar with, well, we'll go into that in a minute, with the In re Sanders case? So put yes or no down there. I'm just curious how many of you have actually watched that. We need to put it into the membership site. I was actually working on that tonight, but the upload was going so slow. So that's the other part of your homework. I would like all of you to listen to In re Sanders. I will get it up into the membership site, and I want you to note down for me the three, there's more, but just pull three ways that Vivek Sankaran reframed the case back. So in other words, tell me what the prosecutor tried to do and how Vivek turned it around and used it and got the court back on his side, like what he did. 3 things that he does. You're gonna notice them. It's real easy. You will immediately identify it. 3 things that he says that takes control back from the prosecutor. You tell me what the prosecutor said to try to get control, and I'm going to give you a hint. They're shaming words. They're put down words about Vivek's client and how Vivek turns that around. You'll notice that and I'm going to give you another hint, Vivek does not shy away from bringing up the ugly stuff, right? The hard stuff. Like perhaps father could be, proven unfit. However, they did not do it. Okay, so he doesn't hide from the facts. He doesn't try to trick the court. Okay, so I want you to just note things down for me. So I've given you some hints, given some of it away. 3 things, okay? Send me that email once you get that done, and I'll email all of you once I get it up there for you to listen to. It's going to help you with your framing. I'm not having you do this to waste your time. It's so that you can get your brain primed to be able to do this for yourself. By practicing and listening and then repeating what somebody else does gets you 1 step closer to being able to do it for yourself. So let's go to stage 4. How are we doing on time here? Let's see. Okay, so it says we've been live for about an hour, so we're doing really, really well here. So stage 4. Stage 4 is your post-trial motions. Can I get some water over there? Or do you have something? Or that Powerade drink, actually. Your stage 4 is your post-trial motions, and that's where you, okay, so you either got the results you wanted in trial, so let's all keep our fingers crossed, because some of you actually will get settlements outside of trial even before you go to trial. It's actually happened to people who thought they were going to trial. Everybody showed up to go to trial, and then everybody went and met in met in a side room or conference room of the courthouse and ended up going to the judge saying we have a settlement. So some of you won't actually have to go through trial, even though you might think you do, because it's all the way to, you get all the way that day and you put all the preparation together. Just because you prepared and you organized for it, if you can come to a settlement that works for you, don't not settle just because you dug your heels in, right? Hold on here. And I'm also not telling you to violate any of your rights. I'm not saying you have to give up rights or be afraid of the trial, but if there's a way for you to get what you need and to be able to protect your rights without going to trial, then absolutely do it. Okay, it may not be perfect. I've had some parents come and say, well, I only got 48% of the time. I didn't exactly get 50, but you know what? It's so expensive and takes so long. If that's what you feel is right for you and what you've got to do, then you've got to do it. You can continue to fight to change this process. You can continue to help other parents. Some parents don't ever get that option or opportunity. It's not a perfect system. Life isn't perfect, but get as much time and get as much as you can with your child. And by the way, don't believe or buy that, hey, just take this 30% of time or 40%. You can change it later on modification. That's the biggest BS. Don't believe them, because modifications are hard, and remember, they're going to base it on patterns that the court's just going to fall right back into their patterns and their status quo. So let's say you had even filed all these motions framing up all of your rights arguments, but you never actually got to argue them. Well, then they're going to default right back, if you end up in modification, right back to their patterns, their bad precedents, and everything else. And I can tell you, modifications can be more expensive than original suits. They certainly are harder, because if you didn't get your rights protected the first time around, they're certainly not going to be easy about protecting them the second time around. Okay? So, after the trial, so let's say you preserved error all the way through the trial. Judge says, I'm going to give you a ruling, or I'll give it to you in 2 weeks. And then your ruling comes out, and the ruling's bad. You got 4 days a month, child support. You were made the non-primary parent, and now you want to appeal. Well, there's a process before you get to that stage 5. And this is the post-trial stage. And I just want to let you all know, I had no idea when this happened that it's like a whole nother trial process around getting your final orders in. So judge renders a final order, but it's oral, or the judge could file an opinion where they write all their reasons that they came to this final order decision. But then you have to get that final order entered. So there's a whole procedure for that. You can object to the orders. You can ask for a hearing on those final orders. So this can get very, very expensive as well. So you may think at the end of that final trial, that's it, my expenses are done. I'm not going to need to pay a lawyer anymore. We just get that order in, it's a done deal. No, final orders can come out and be completely different than what the judge stated in oral. So by the way, if they state their orders orally, you need to be taking notes on that. If you didn't take good notes and you need to know what it is and you can't afford entire transcripts, you can ask for just the rendition of the orders on the transcripts. So you can get them to expedite it and get you just what the judge read into the record as the order. They have it broken down in pages. They do organize it they have a way to look up, when they indicate that the judge is rendering orders, judge is speaking, and so they note, they have a, what do you call it in the back? Index, sorry. They have an index that they use, the reporters do. I went to court reporting school, by the way. I used to employ them in a legal medical transcription business I had prior to my divorce. And so I know the process that they have, plus I've seen it in courts. You can ask for just certain sections of the transcript. It's very, very important, because some of these trials go on for 3, 4, 5 days, and it's very, very expensive, thousands of dollars to get those transcripts. But if you just ask for the rendition of the order so you can see it, to see if it matches the order that if you lost, it's usually opposing counsel puts the order together to make sure it matches. They will throw things in there to their benefit. They might throw certain language in there to their benefit. So here's where your family law book comes in handy, is you're going to look and see if there's basic orders in there, or there's information and training about the legal language in the orders. If you do not find it in there, your family law practice manual, then you're going to need to go back to the library. Now, you have very limited days on this, you guys. So remember how I said conserve your days and your time, or you may need to get a paralegal to look at this if you're working a lot of hours. And that is, you need to pay attention to all of the language in there. And let me point out an example why. In Ron's final orders, he had to pay spousal maintenance for a specific amount of time. His attorney was actually really smart. We did not know this at the time or what the reasons were, but his attorney put in there that he had to pay spousal maintenance according to Chapter 8 in Texas. That particular chapter defines how and when that other person qualifies for spousal maintenance. So there may be an order for you to be paying something to the other parent, but there may be parameters, things that the other person has to comply with in order to qualify or continue to qualify for that payment. So it's not just a straight up money judgment necessarily, where they're just dividing assets. If they tie it to a specific statute that has a specific purpose, and in Texas, that specific purpose for Chapter 8 is to help a person who might have been staying home during the marriage and needs to update their skills so that they can improve their financial status, or they may just be giving that to them for them to get on their feet with the household separating, so the court may have seen them as a little more dependent. So in other words, if you're the primary earner and the other one doesn't earn as much, they may be using that to somewhat balance, but they put provisions in there for them to continue to qualify. One might be that the court has to review it every year. One might be that they have to be getting extra education, like actually prove that they're improving their skills on that yearly check. And if they don't do that, they may stop qualifying for it. So that's why I said pay attention to it, because there may be ways for you to get out of things. If the other person decides, hey, they're just going to blow all this off, there may be ways for you to get out of it. And there's other things too, but that's just one of them. So make sure that everything in there, if it refers to a statute, you understand that statute. If it's a particular right that you're getting protected in that order, like possession time with your child, then you want to make sure it's enforceable language. Right? So there's a lot of things you need to pay attention to, and that again will be in our stage 4 segment of our course, Navigating the Court Process. So you can look at every step of the process and make sure you're crossing the T's and dotting the I's, because that final order, if it gets messed up, there are little things you can do that called like nunc pro tunc to correct errors, like obvious errors. There are little things like clarifications, so things that maybe some of you don't know that can be done without you just going in and just bam, I need to file a modification, and opening yourself up to that, as we will talk about that in that course too, about why you don't want to just so quickly open yourself up to modifications. Modifications in some states have no presumption for like your parental rights. Worse than when you go through it originally, right? So in an original suit, both of you are presumed to have the right to be the primary of your child. That's how the states do it. Constitutionally, you're both presumed to be fit and be acting in the child's best interest. But that kind of gets washed away in these states. But in modification, they may completely have nothing in the statute that's restricting them from just saying we take over, period, and it becomes worse than when you went through it the first time. I know it's that way in Texas. It's flat out a worse free-for-all, and then they really start piling in all of those other layers of people. And you know how I told you tonight is a focus on parental alienation, so we're going to get into that. Is in your initial proceedings, as well as in these when you go in to do modifications, they start bringing in tons and tons of court-appointed people. They'll do it in final orders too. They will put in things like, if you have a disagreement again, you're going to go to a parenting facilitator, and they're going to review your complaints before you can come back to court. These people that they place into your life can also become additional people that start attacking you, right? You may end up paying for additional people to attack you. So think about that before you ask attorneys to add more people in. And this actually should have gone into stage 2, which is everything you ask for, put a dollar figure next to it. Everything you ask that attorney to try and get from the court is going to cost you money. So you need to make sure that every request you're making is worth that money. There have been people who fought over pianos or fought over a refrigerator, and by the time everything was said and done, they paid more than 10 times it would have cost just to buy another piano or refrigerator. So be very mindful about that and what you're asking them to do. That's related somewhat to make sure what you're asking, there's a form of relief for it, but also make sure that what you're asking for, you can afford to ask for it, or it's worth adding that request in there. Okay, so let me see what stage 4, what else I had. Okay, so if any of you guys heard of zero-sum theory, do any of you guys know game theory at all? And then we'll go into stage 5. Yeah, I get that. Some of you guys are saying, all I want is my kid. I just want, to be with my child again. The court knows that. They are using that. They weaponize your child so that you'll stay in this process. So yeah, we get it. That's all I wanted as well. So any of you guys understand game theory? Zero-sum theory. Okay. This whole process is built on zero-sum theory. So there's actual cultural discussions about how, you'll see it a lot in the UK, where they'll talk about if they award, and there's some of the language that we want you guys to immediately have red flags to when you hear certain words. That's not the constitutional way of doing things. They don't award your rights that you already have. But in the UK, you'll see a lot of discussion about moms. If they give dad some time with the child, they're actually taking that time away from mom. That's how they'll articulate it. That's how they'll position it. So it makes it look like the other parent, whatever they get, is taking, right? And that's what's happening in these courts and that's why they're having a tough time with the equal part of it, because they see it as one parent's a loser and one parent's taking from that parent who's losing. So in those particular situations, the examples that I saw were moms. They're saying, well, for every day that I give dad, that's a day mom doesn't have. And as wrong as that is a cultural thing that you have to persuade them off of, and you've got to refocus them. That's where I'm talking about reframing. You need to reframe them into, the child has a right to be with both parents. The child's rights should not be violated just because the parents are in disagreement. The child's rights are the mirror opposite of the parents' rights. So what that means is, if you have the right to care, custody, and control of your child, then your child has a right to be in your care, custody, and control. So that's how that works. That's what that means when Ron makes those statements in his Protecting Family Rights course. Okay, so the other thing is that I wanted to mention to all of you is you lose the attention of the court when you don't prepare the court for how you're framing things. They will shut you off when they don't recognize something, which is why you want to be very organized, and you want to deliver these arguments in as simplified form as possible. Otherwise, they will just shut off on you. And this is what the attorneys worry about. And they say they'll go with the other parent because the other parent is satisfying what the statute's asking for. So I watched some videos the other day, and there were judges explaining what it was they were looking for, and one of them was saying how she just sits there with a notepad and checks off, writes down every time a parent fulfills, in Texas, what's called the Holly factors. So all they do is compare the two parents, and they compare them based on the best interest factors. That's what the Holly factors are in Texas. And so they just look at, all right, dad says this, you know, his plan for the kid is this, and mom's plan for the child is this. So they look to see you checked all those boxes off. So again, that's why I said you want to know the statute, what the statute's asking you for, and you want to make sure that you're also providing what you need to satisfy the statute without opening yourself up, without telling the court, hey, I'm asking you to make this decision. No, you're saying, okay, look, I've satisfied your statutes. You can still challenge the statutes, you just don't ask for benefit from using that statute. So in other words, if you do fulfill the factors for best interest in your court, then you're not going to want to turn around and say, okay, I've shown that I'm somewhat better than the other parent, so I get to be primary now, right? Okay, don't do that. All right, that then would be utilizing the benefit of the statute. And if you go to argue these constitutional things and in the appellate court, when you didn't get your way, they're going to say you're a sore loser, you're trying to relitigate in the appellate court. That's how that happens. There's a fine line. So parents get confused with what is satisfying the statute and what is consenting or conceding my rights. That's the tricky part here. So be aware of that. Stage 5. So we're going to go into stage 5. And that's the appellate process. The appellate process is dependent on what? You guys should know this now. The trial court process. You cannot go to appeal without preserving those appellate issues in the trial court process. So how many of you feel that you've been doing that throughout what you're doing? Or do you just feel like you're constantly on defensive, right? If your whole case is defending on this and defending on that, and as soon as you overcome one thing, and let's say they tried to get a protective order, and wow, you beat that, then you're responding to another allegation and another allegation, and everything is just all the time is being used up with you being on the defensive. They've already pretty much now have positioned you, right? And I'm going to explain something to you on that too. That zero-sum game theory that I explained to you, there's another piece to that. When the other attorney rolls their eyes at you and huffs and puffs and treats you like dirt and puts you down, you notice it starts getting contagious. Like maybe the guardian ad litem then starts picking on you. The judge might start rolling their eyes at you. It's kind of contagious, right? So that's actually a phenomenon where they call it the community will start stepping on the person that's being victimized by somebody. Community will join in. So the court right now is the community, and they will join in and start picking on you because you're not repositioning that properly, and you're letting them get away with that. You're not responding back with, basically you got to beat that bully up. You got to punch them back in the nose. And if you're not doing that because you're just like, hey, I want to come across as nice and a good person, I don't understand why I keep getting the shaft and the wrong end of the deal, that's why. So if you don't understand game theory and zero-sum theory, you want to look that up too, because all of this is about strategy. There's some very simple things you need to learn about power. And there's a power book out there too, by the way, and I will be giving assignments from that in the whole course. We're not going to do that tonight. I already gave you like 3 homework assignments from this, so we won't do that tonight. But there's a lot of strategy that we teach you and talk about. You will feel very empowered, and you will get very confident with delivering these arguments without looking like a pompous ass, without, and I hope I don't get banned for using that word on YouTube, but there are ways to deliver this where you just look professional. Okay, you want to go in looking professional, you want to go in sounding professional, and you want to come out sounding confident and professional. That also will help your brain not go into that PTSD and that anxiety, and help you not constantly suffer from those triggers that's happening, that's getting you, that's allowing that person to position you into that role in the court. Okay, so you will learn to come out of that role. And in fact, when I learned to stop feeding that zero sum game that they were playing, do you know the other attorney actually got ill? I mean, physically ill. And he wasn't a horrible guy. He wasn't a bad person. I had long talks with this guy, but it actually started to make him ill. He actually couldn't handle the fact his insides were telling him that what he was doing to me was just wholeheartedly wrong. He never said that to me directly, but I mean ill like flu. And this is not during a time when everybody had the flu. He was the only one getting sick. He missed a few court hearings because of it. So, and he was otherwise a very healthy person. He always was very shocked. He's like, I don't know why I'm so ill. And I'd be like, I know why. You know, it sounds heartless, but it's, you know, when they're attacking you and they're doing these things, it is evil, and evil will eat them from the inside. I've witnessed it from my own eyes. So this does work. So back to stage 5. So you're in the appellate process. You've prepared everything you could in the trial. You've stayed organized like we told you to do. And now you're ready to do the appeal, but you're also getting stressed out. Why? What has happened throughout this entire court process that we haven't talked a whole lot about that I brought up? It's the alienation, right? So you're frustrated. You know the appeal is going to take a long time, but how many of you feel like you're already getting alienated? And if this takes longer, that alienation is just going to become final, right? So, and tell me, what makes you think it's alienation, for one? I know some of you have sent me what you thought was alienation, but let's make sure it's actually alienation. And I'm not saying go through the court process and get expensive experts to prove it and all of that. We'll go through the course about that. But what I'm saying is, when you're going through the appellate process and you got orders that weren't great, and you're not seeing your child, and you're getting alienated, what's another thing you can do during the appeal process? You don't have to wait to do. So if you haven't said it yet in the comments, it's enforcement, contempt. Those orders are enforceable unless somebody stays the orders or suspends them, correct? Now, some people will find that their judges will be upset that they've appealed and will say, well, I'm not going to enforce the orders, or I'm not going to, you know, do contempt, which, by the way, then you can take up the chain, because if you file contempt, if their orders are being violated, that means that the best interest of the child is not being protected, which is the policy of the state that the judge just enforced and memorialized in your order. So now you've got a whole nother game you can do, a whole nother strategy to get back in front of that court and get something enforced. I used this method. As much as people want to say, oh, it doesn't work here and it doesn't work there, you know what? I went to every channel. I was persistent and insistent. And sometimes the laws, it's a lot like, I like to equate it to this. It's a lot like insurance. Kaiser, for one. I know they don't have Kaiser in Texas. They have it in California and some other states. And I remember my former mother-in-law, when she went to work for them, how she said that they had a policy of telling parents no for procedures that they needed. This is including serious procedures they needed, like cancer treatments or tests to confirm diseases and cancers and things like that. They had a policy of telling them no at least twice, making them go through that approval process a third time. And the reason is they saved money. They saved money by doing this because, you know, the majority of the people did not pursue overcoming that no, that objection. So when you are pursuing the contempt and the enforcement, you have to be insistent. By the time I got heard for mine, I had over 250 violations against the other parent on mine. And by the way, we did eventually accomplish, so we had success with it. The judge did order jail. And yeah, I see that, Robert. He's saying he has it all. Good. That is, as heartbreaking as it is, as hard as it's been to miss your child, having a bunch of violations is actually the best position you can be in with parental alienation. So this entire process has created the environment that feeds that alienation, right? The process rewards it. Guardian ad litems eat it up. The statutes support it by saying, hey, this is the preference of the child now. So whatever parent could pressure that child into going one way or the other, or into utilizing the court for all of their false allegations, or all of their inflammatory remarks. I've actually sat in a courtroom where a mom said that the best thing that could happen was for the father to be castrated. And that person won. They won custody. So you've gone through all of this. Now you need to utilize the process that you're allowed to use to get that enforced. Now, like I said, there's some caveats to this, because you're the not favored parent, because you're the non-custodial parent, there are lots of laws, like let's say in Texas, the 2503, which is the penal code for interfering with child custody. For years, they did not enforce it for a non-custodial parent. They saw that the way they interpreted it was only a non-custodial parent could kidnap a kid or interfere with the order. They saw the primary parent as, hey, if they decide that that child shouldn't be going with them at this time, they're the decider parent. They're the chosen parent. They get to make the decisions for the child. What they forgot about, the judge didn't leave all of that decision making in the hands of that parent. So yes, you do have a task to educate them, and yes, you are being shut down in a lot of places, and a lot of people shut their doors and they don't want to hear from you. But just look at that as like the Kaiser process or any other insurance company that you've ever dealt with. They're going to turn you away and tell you no at first. So make their job easy. Here's what my solution was. You've got to know how to put your motion together, put it together exactly the way the rules and the statutes say, where you identify the exact violation, the exact date and time, the exact place in the order that says it's enforceable, right? Yeah, I see that you have that exact statute. That's correct, Robert. That's exactly where you want to go with it. Put it all together and make it very, very simple. And you're going to have to get heard. There's just no way around it. You were given an order. You've got to try and get it enforced. By the way, if you can't get orders enforced, what good are they? Right? What good are these orders if they're not enforceable? It was pretty much pointless. It was like you didn't protect any rights at all. So the other part of this process, for all of you who are advocates for other parents or for yourself, and activists, but most of you are helping others, you are going to need to let your legislators know how the statutes are working or not working. I remember when I called mine, at one point she's like, you know what, we made laws for that, but we don't know how the laws are actually being interpreted or used until somebody comes and tells us. So check, because maybe there is a statute in there and it's just not being enforced or used. What do you want your legislator to do about that if they're not using it? Okay, I kind of laughed at that, but it's not a funny deal. It's serious. And one of the things that legislators found is that sometimes when they leave a gate open, for instance, 1 year before we had actual standard possession order, where it was actually outlined throughout the whole statute, they just sent out a mandate to all of the judges a couple years before that and said, hey judges, create a parenting plan. Create one for yourself that you like, that you want to use in your court. And 2 years from now, when we meet again, we want to know what all your parenting plans are. Only one court did it, and that was in Travis County, which is Austin. So the legislators ended up adopting that, putting it in the statute and saying, I want all of you judges to follow it. That's your minimum. Well, what happens with judges, and you want to utilize the habits in the process. It happens with judges, it happens with attorneys. Attorneys use templates. Judges go for whatever's easiest. So they look to the statute, has it all laid out. That's why the standard possession order is so common, and that's why it's the default. It's the only parenting plan in the statute. So for parents who want equal, bring that actual plan to the court. Bring it already written out in an order, the way you want to see the result. So remember when I started at the beginning, you always want to know what the end looks like. So that's the fourth homework assignment that I'm going to give all of you. And I want you to write up an order that looks exactly like orders your state makes. I want to see an order with the result that you want, the exact result that you want.
Just the custody and possession part, right?
Yeah, just the custody and possession, by the way. We don't need to see all the rest of the parts of your orders, like the financials and the property divisions and all those other things. Just the custody and possession. So those are 4 things that I gave you to do in this. And I want to see how you're defining parental alienation and all of those things, because we're going to have to talk about that in some other workshops. But this one today is court-induced parental alienation. You ended up with parental alienation because of the entire process and because of all the people that were brought in to serve the court actually became a wedge between you and your child. They made reports that made you look horrible, that made you sound horrible, that regardless of what the court order says, the other parent's sharing with that child in some way, shape, or form, right? Or that child is developing ideas about you. And I'm not saying this to get any of you down, because I know you're already missing your child, you're already down, but you have to be able to either think about this or have somebody that's doing this for you. By the way, we do have some people in this membership site that just help parents who are just coming to these so that they can work the parents through it, because the parent themselves can't handle it anymore. I didn't go through all my own emails for my court, organize all my evidence. Ron did it. So if you have another significant other who does it, yes, it's hard on your relationship, but what's even harder on your relationship is if you don't do these things and you don't fight as far as you can fight, so that you feel good about you did what it took, you did what was in your control. And even if you don't get the results that you wanted, you at least put your best shot forward, right? That's what's important in our lives, and that's how we maintain our integrity, and that's how we stay whole, and that's how our body heals, is we take difficult situations and we work through them. It's not much different than, so when you're being victimized from that parental alienation, it's not much different than if you had been abused as a child and now you have to work through it as an adult, because you might encounter something that triggers it and you can't actually overcome, you can't actually face whatever it is that's triggering that. It might be something at your job that you've got to do, and if you don't do it, you're not going to be able to work that job anymore. So you have to be able to work through this too, or you won't be able to heal. It's just the nature of how we are as humans. So a couple more things that I want to go through. Make sure you put all those down for homework. I want to know how you're defining parental alienation, so that next time when we do a different workshop on it, we can go over with you how to prepare that portion of your case, right? I will tell you, bringing in expensive experts to try to prove parental alienation syndrome is generally not the way to go for most of the cases. It's very, very expensive. That too can become it can take on a whole nother life of its own in your lawsuit, can't it? Some of you may already know that. The parental alienation expert, they can completely like side with you, and the court looks at it as, well, you're paying them. So, you know, like mom or dad, whoever's on the other side of your case, could be paying for their own expert who comes in and counters yours, and pretty much makes the two things moot, and you both wasted your money. One expert says the opposite of what your expert says. Now what is the judge going to do? So either they're going to buy one side or the other, or they're just going to say it's moot, right? So it all depends on all the other facts in your case as to what you need to bring in. I'm just saying in general, I haven't seen that help a ton, and just spend a lot of money, and then you don't have resources to push this through appeal, or you don't have resources to even, you know, transition your life and use other solutions for reconnecting with your child. There are other things you can do in other ways, by the way, that you can reconnect with children or make sure that you're preserving a legacy for them if these courts do cut you off. One thing I had to do for a while, because I just couldn't get the court to, you know, budge for me for the longest time. And so my children, if the ex didn't want to send them, he didn't, right? So my kids got more and more and more defiant and just rude and disrespectful and not wanting to come. And when they did, they acted up. And I couldn't get that court to budge and couldn't get that court to budge. So when I talked to a therapist, the key thing that therapist did was put it into a different perspective for me. One is, he said, it's a lot like a grieving process, except it's worse because you're grieving a living child. And so the other part of it is, we are not prepared to not be able to raise our children to the age of 18. We always had the belief that when you had a child, nothing could come between you and that child, certainly not a court of law where you didn't violate any laws. You didn't believe that a court would be keeping you from your child. And so you have to come to the realization that there are some things not in your control. What is in your control is how you frame your case, is how you set yourself up, and whether or not you're going to set yourself up as a victim, or whether or not you're going to make it very, very difficult for them to pick on you, and whether or not you're going to you're going to blaze those paths that will serve to protect your children and their children later down the road. So even if you don't get the result that you wanted, you're at least paving the way, right? So not everybody succeeds, or at least you don't see it as a success. But every single one of you that presents these arguments actually is laying another paver down for this path, because movements are, you don't really actually understand what they've accomplished until they actually accomplish what they set out to do, right? You can feel sometimes like you're not making any progress, when in actuality, it maybe took 1,000 individual efforts to get somewhere. Like in the Cesar Chavez thing, it took many parents stepping up and getting arrested and saying the word, the strike word that the court had imposed an injunction against, before they actually achieved their goal, which was to get benefits for their, I think they were grape pickers, they were farm workers, and they didn't get benefits based on their nationality. So they fought for that, but they had to they had to break these injunctions that the court put in place. So I did want to point out, I read on someone's Facebook page today, it's none of you guys, but I really liked it, and it was, at one point, the Holocaust was legal, and anyone who fought against it was punished. I want you to think about these things. At one point, women didn't have rights, and women who fought for it, so women not having rights was legal, and women who fought for it got punished because it was illegal to fight for rights. And at one point, slavery was legal and people who fought against it got punished. So right now, it's you have a little bit better position in that it's not actually legal what the courts are doing. The states are upholding that as legal, but you actually have rights that you're trying to get respected and enforced. Whereas in a lot of the case examples that I gave you, they didn't actually have rights. They had a larger hurdle to overcome. So I just want you to put it into perspective. And that's hard to do when you're not getting your kid, you're not getting things the way you need them to be, and they're using the most important thing in your life to hurt you. They're weaponizing your child. So I get it. I know that's the most difficult thing to do, but I'm telling you that if I could do it, you can certainly do it. I had four children, all 3.5 to 4 years apart. They were all at different stages in their life. They lost activities they were doing. All of their personalities changed. So, you take one and multiply it 4 times. And if you don't think that's hard, then try having your older children start alienating you and joining in. It all became like a cult. And it just snowballed from there. So if I can get through this, you guys can get through this. Not everybody will get the same results, but I can tell you that you're definitely not going to get good results by continuing to do things the way that has allowed them to take advantage of you, right? And that was cute, Kendra. Kendra says in the 80s they had to fight for the right to party. Yeah, and it wasn't in the 60s. They had to fight for the right to. There was like certain dance styles and different things that they had to fight for. I'm gonna look. Let me make sure I covered everything, and then I'm gonna look at your questions. I did have a comment that I put that if you don't know these things, you're not going to be able to protect yourself. You won't even know when a violation happens or what the violation is. That's part of the requirement in law, is you have to know what to call a violation, and you have to be ready to make persuasive arguments. So when you're studying this stuff, like objections, for example, when you object to something, you can't just say objection. You have to say what kind of violation you believe they committed. So if it's hearsay, you have to say objection, hearsay. And if the other side argues it, then you got to know how to protect that objection and argue that. So there's a back and forth that goes on, right? So in addition to needing to know all the rules and procedures, you will also want to get those books that I mentioned to you, the objections books, the book on evidence, discovery, family law practice manual. I know I've repeated it, but it's that important. You also want to watch as many court hearings as you can. If you can't go in person, find out if you can watch some courts that are on video. Look up other states to see example hearings so that it's as close to what you're going to go through to familiarize yourself with the process. It tricks your brain. You don't get as nervous. And then expect the unexpected, okay? So I'm going to give you a little bit more on strategy before I go to questions. A rule of thumb that I use is for every request that you put in front of the court, I say cost money, right? Put dollar figures in front of it. And make sure you know what result that request is going to get. So I'm just reminding you some of the concepts we went over. Most of you already know that are here today that most of the narratives that the courts push forward are usually false and misleading, right? They're created to justify the actions that they take so they can create something out of nothing. And they want to make it look like there's controversy where there's not, to address some kind of restrictive order that they put in place. Those are things you're going to have to point out and counter. So in this whole course, Navigating the Court Process, you're going to learn what it means to define your case for the court. It includes learning about case law and legal authorities. I think I mentioned to you guys, Ron's annotating case law. He's going to put that into the membership site. If you scroll down the page on the membership site, I don't know if you all noticed, but I've added an appeal course. We are populating that. So you're going to see more things added there. You need to make sure you're scrolling through those and checking them, is we don't always send out emails until we get it more populated, but you may see things pop up. There's concepts course in there to define some things for you and help you get used to the legal language that lawyers are using and courts are using, so that you start to be able to speak their speak, you know, kind of like talk the talk, walk the walk, understand what you are asking for in the right language. You know, by the way, don't use words that you don't see defined in the courts, because if you do, it kind of leaves them open for interpretation. The way you narrow and limit their power and their abuse of power is by holding them to specific terms. So that's another way that you can take control back in the court, is if they say a word and it doesn't mean something, you reword it, right? Have you ever heard about that? Like mirroring language back? So you're going to reword it, and if it's something that's defined, yours is going to prevail, because the defined statement in law is what prevails. They can't, the undefined becomes arbitrary, overbroad, you know, those things that violate the Constitution. You guys have been learning. So we're not going to have Ron explain. I was going to have him explain more protections, but you can get that in the actual full course. What are some of the layers that we went over that the court adds on you to get you to give in, scare you out of these arguments? They layer in a lot of costs, right? So it's money. They use layers of burdens in the form of financial costs. So one of them could be, you might be paying for 2 households while you go through this. So you're not completely divorced. So you're paying for your household, you're paying for her household, or if you're the woman, you're paying for your household, you're paying for his household. And the longer they keep this going, the longer you have to pay. So there's another strategy that I use, and that's get through these courts as fast as you can and get the hell out. Because the longer you're in there, the more you're paying. And they're racking up bills when you don't even know it. Lawyers are working on things you don't even know about, and so you're going to go in the hole. They are going to dig a hole for you. They know how many assets you have. They're going to use that up, and then they're going to get you into debt. So you need to be very cognizant of that and not let that happen. And they get access to everything. And even if you fight it, remember, fighting things costs money too. So you have to tear this process down piece by piece and make sure that you're staying focused on the right things, because they'll get you distracted all over the place. They'll create this windy road and make you take the long way to get to the same result. Remember, keep the end in mind. What is the result? I remember the first time I went through, I got my ex to settle when I finally wrote up that final order, and I took it to him and I said, do you know all these things they're telling us that we're going to need to do and cost us? This is all it's going to be. I literally took the piece of paper and put it in front of him. I went to the law library and got the template. So by the way, when you write that final order, go to your law library or go online. A lot of the states online have links. We have a blog that has links to all the states where you can get the templates to your final orders. They're usually fill-in templates, and create the section of the order that I gave you in your homework there, the parenting plan, the custody rights. And once I did that and I took it to him in Texas, it was from the Texas Young Lawyers Association, where I got the final order template, filled it out, showed it to him. He's like, whoa, so we're paying all this and they're not even going to care. They're not even going to care about any of this. Nowhere in your final order does it say, this is the gal's report. Nowhere in your final order does it say, well, this is the child's preference here. No, it just says who has what days and time, and who has what rights, duties, and responsibilities, and when, and who has what holidays and when, and where are the pickups. And when you actually look at it, none of that other stuff mattered. It was all noise, expensive noise. That was the only time and the only way that I could convince him that this was an unnecessary process. He signed it, I got it finalized, and we got out. That was the first time around. That was before the modification. Okay. So if you guys didn't watch my video on the parental alienation business model, you want to kind of get familiar with that. I'll put that into the membership site too. The business model, we've touched on it, and that is they're going to appoint as many people as possible. So the more you say you want something and the other parent says they want something else, they're going to bring in, the court's going to bring in other people that get on the payroll, your payroll, by the way, that you're paying them, that come in to try to, one, create reports that persuade the judge one way or the other. Some will create neutral reports, which are pretty much useless to the judges, right? They want them to choose sides. So they will have you spend a lot of money to get a lot of these reports. Robert, I know you've been through a lot of that. And that also puts in some more layers on that alienation, because now you've got other people talking to your children. So your kids could be getting interviewed by the judge. They could have therapists that they're having to talk to now, which, by the way, you don't know what these therapists are telling them. And then you have a gal who has complete access to your child, can go places with them without any parents. I was told one time somebody picked up my kid and took him bowling or something. Who knows it? Some attorney or employee from their attorney's office did it. You don't know anything about these people, what they're telling the children. My kids, I know, eventually would come and say, well, I'm just going to tell the judge, right? So I was shit. I was dog meat. I had no authority anymore because of all these people coming into the process. So now your ex doesn't even have to do a whole lot. So that's what I mean by this process alienates. It's a court-induced parental alienation. Your ex could not have even dreamed of a better model to help them hurt you. And in the process, it hurts your children. But that's the process they're using. This is the process you're fighting against. These are the things your attorney doesn't tell you, that it could turn out like this, that it could cost you more money than you could pay, that the money you owe the gal can be converted to child support and could land you in jail. You can be put in jail for not paying your gal, right? So a lot of this stuff, if you learned it in advance, you would make better choices and decisions. I know a lot of you guys would. I know some of you are dealing with this and now you want to know the way out of it. So there comes, that's why you're in the membership site. Ron's going to be putting a gal motion in there. I need to edit it. A gal motion to help you get rid of gals. We've already put a child supportability to pay motion in there. Remember, these are samples. These are not file ready. This is so that you can actually go get templates from your state and add these arguments in there, because it has case law and supporting authorities. And then he's making videos, and you can watch those and learn how to argue these things. Take it to your attorneys. By all means, we tell you, use attorneys whenever you can, and help them learn to persuade your judge with it, and get your attorney's input too. It's valuable when an attorney says, well, I'm not going to use that. Well, don't just let it sit there. Well, why not? Say, why not? Can you have them give you the argument? What's the argument you're afraid is going to be used? And look up those cases and get that argument and bring it to us. We'd love to put some of that into the membership site if we're not already working on it, and you bring it and it's something we think it will benefit our members. We'll break that down. We'll do it anonymously, but that's how you guys will learn to help yourself and help those attorneys help you. And like I said, if you can't afford an attorney anymore, you can't find one who will do it, and you have to do it on your own, well, you have the information as well. Just always get somebody on the back end to give you technical information, procedural information, because that's where I usually see them get parents. Although most parents that we see working on this now know the rules and procedures better than attorneys, and then most of the time now the others attorneys are trying to lie to them, and these parents are calling their bluff. It's actually it's a wonderful thing to see, while at the same time it's very disappointing to see the state of the legal field, which, by the way, law used to be a trade, and And it wasn't like this with the Bar Association monopolizing it. It used to be that everybody learned their rights and law. I think back to Benjamin Franklin days, right? They had lots of rules, and all the people would learn, well, a lot of them would learn the law, because that's what keeps us a civilization, isn't it? That's something that a lot of us have gotten away from, and why we see so many problems coming up now. We've gotten into the mode of, let's have somebody else do it for us. And yes, we know you're busy, and you'd much rather be focusing on raising your child, but this is the position you're in for whatever reason, and I believe it's because you're all strong, and you all will make a difference. You are making a difference, and you will change these things for everyone else. And once that happens, then it will become the exception and not the routine, not the norm. So let's see some of your questions. Sorry it took so long to get to them. We've been on here about 2 hours, so I'm gonna have to go through them quick here. Let's see. So we've got lots of people say they're dealing with parental alienation, and I agree. Some of you called your orders abusive orders. Very true. The process is abusive. It's very punishing. They do that by design. They don't want you challenging them. They want to play super parent, by the way, and they want you to assume that that's the role they're allowed to play. And somebody said they're starting the Green Book in the course tonight. Excellent. By the way, I didn't mention oath breakers. Oath breakers is how you prove that your court is a state actor. Some of these courts try to get out of saying the Constitution isn't being applied because it's a two parents versus, parent versus parent case. And they're saying, so they don't have to apply the Constitution. Well, one, they took the Article 6 oath, so the Constitution always applies, but they only take it as due process is notice in a hearing. Whereas if you can show that it's a lie, that they're not state actors, they are state actors, then they absolutely have to apply these rules for your fundamental rights. They do anyways, but part of the way they're wiggling out of it is by saying they're not state actors. They're just saying that you've asked them to provide you, a lot of people call it equitable relief, which, by the way, they're not just courts of equity. If you have a family code, they are a court of law.
Court of equity has to follow the Constitution anyway.
As you heard Ron say, the court of equity has to follow the Constitution anyway. We wrote a blog on that just recently. You can look up, it's about the brief that was filed recently. And so we talk about that because we do see that a lot, especially in the older states, like on the East Coast, because their systems are older than the ones on the West Coast. You'll see them using a lot of that older language. Don't let that fool you. Get them. We do everything in writing to protect our rights. That is true. Let's see. I want to get to the question somebody's commented on Roberts. What is the constitutional basis to say that they cannot use your refusal against you? The constitutional basis, well, first of all, you have to give particular situations, but one of the examples I have is the financial affidavit. Recent situation that I was reviewing was the person said that they objected to presenting financial affidavit because there was no child support being considered for it, and they felt that it was an exploratory search, but the statute gave them a right to award attorney's fees based on ability to pay. So the constitutional argument would have been that you didn't receive proper notice of the ability to pay standard.
There's something different here.
Okay, so Ron wants to chime in on this.
So there are two aspects here. First is your Fifth Amendment right to not speak against yourself. That applies differently in civil cases, so you can be punished for not speaking in civil cases in certain circumstances. The other thing you might be talking about is whether or not you can be punished for exercising a fundamental right. You cannot be punished for exercising a fundamental right. For instance, the right to divorce is fundamental and guaranteed by the First Amendment. This whole process is punishment for getting divorced for so many people who are here because of divorce. And that is one way we attack this, and it will ultimately be defeated, because they cannot punish you with loss of the rights to your children simply because you chose to dissolve a marital association, which is your First Amendment right to do.
Okay, so here's another comment that Robert made. He said most state constitutions mirror the U.S. Constitution. And then the next commenter, for the people, by the people, said, I don't think that's accurate, but it could be true in some aspects, depends what you mean. And Robert says, as far as states guaranteeing our rights. So my response to that, Robert, about most state constitutions mirror the U.S. Constitution, in some aspects, yes, they do use the framework. However, there are a lot of nuances. Each state protects your right differently. And again, I'll use New Jersey as an example. New Jersey's constitution, they said, I think it was their Article 1, said that it protects, they said it protects your rights, even though it doesn't mention anything about equal protection or due process. So they had a particular way of interpreting that section to comply with the federal constitution. So basically the state constitutions, they can convey more rights than the U.S. Constitution. They cannot subtract from the rights from the federal constitution. So I'll give you another example. In Texas, their language in
First Amendment free speech.
the First Amendment free speech language is written in positive, right? Positive form. And the
Right. So they have two different places where they protect speech. One of them is written in the positive, and it says people of Texas have the right to speak freely on any subject. Right? And then that contrasts with what the U.S. Supreme Court says, that says Congress shall make no laws limiting speech. Now, there's also a section of the Texas Constitution that says that same thing. So one is positively stated in that we recognize you have this right. The other one is negatively stated in that the government has no authority. Right? And so that's important in certain circumstances. In some ways, Texas has articulated that the right to speak freely is slightly stronger than the federal protection, which is already almost complete. But Texas goes a little bit further than that. For instance, prior restraints in the federal system are highly disfavored, but not per se unconstitutional. In Texas, all prior restraints are de facto unconstitutional and have to be justified. So that's just an extra level of protection. Right. Now, there's also an argument to be said that when the statute says, the Constitution says Congress shall make no laws, that's actually a jurisdictional limitation, and the courts have no authority whatsoever to impose First Amendment limitations except where the Supreme Court has established exceptions. This is important because one of the arguments they make is that because both of your rights are equal, that they neutralize each other. However, if the constitutional right is stated as a jurisdictional limitation, even though both of you are equally protected, that cannot convey jurisdiction to a court that the Constitution removed. So if the Constitution says, shall make no laws, there is no exception when two people disagree or two people's rights clash. That doesn't convey jurisdiction to the state, right? So their whole argument there is meaningless in the face of a jurisdictional limitation. And the Supreme Court is moving ever closer to considering those things jurisdictions. Just last year, they said any statutory mandate on time limitations in a case is jurisdictional because Congress controls jurisdiction. Well, also, the Constitution controls jurisdiction, decides what jurisdiction the courts have and what jurisdiction the Congress can and cannot change. So if you follow that logic, and if the Supreme Court follows that logic, then the First Amendment becomes a jurisdictional bar. And they have used that logic in terms of religion and freedom of religious organizations to manage their own internal structure. They have clearly said that the government has no jurisdiction to involve itself with the internal political or legal matters inside a church or a religious organization. So all of that is there and supported. And so we make those arguments and we help you bring those arguments in a way that we think is very powerful.
Yeah. And Kendra, I saw you guys making a comment about, no, we don't have the books in audio format. So Kendra, send me an email. I'd love to talk to you about that. You said you do some voice work. So that would be a wonderful project. I'd consider working with you on about getting these books into audio format. Because Robert, I know Robert, you drive trucks like we do. So listening to your books can be very important. I know that like Monica, she would listen to our online videos from our membership site on her phone while she was driving, because you know you can stream those and listen to the videos there, but the books in audio format would be wonderful. So we just haven't had time to do that. Some books Ron listens to, I think he's listening to Gene Owl books, the Clan of the Cave Bear series, and I think the third one, Mammoth Hunters, is 34 hours long in audio. Okay, so let's see what else you guys have asked. Is family court inside Superior? Superior as in, is it called the Superior Court, or is it superior to what, Kendra? I'm not sure what that question is.
New York, the district courts are superior.
Yeah, Ron's saying in New York, the district courts are superior courts. It can be kind of confusing, you know, if you're thinking of the hierarchy of the words, right? District, superior, but some district courts are called superior courts. And I agree, For the People says it depends what state you're in. That's true. Somebody, let's see. Okay, so Van, you said you want to see more details online about the package of motions. Ron is going to put more of those motions into the membership site. It just takes us a long time. He says it's a difficult process to get them in there. So he is working on that so that you can look at those and read those. And for those of you who can't afford it, you're welcome to type stuff into your motions, right? So you don't have to buy those from us. We just make those available because they're in Word format, and you can just go in and change them. So for those of you who can afford, and we thank you, by the way, for your investment, because we donate more time back into this than we make. And so that helps us continue to develop and evolve these materials if you do purchase. But again, we want to make it easy for everyone to use these arguments. So you can type that into your own documents if you like, for your own usage in your own cases, and we will get more of those up there. So thanks, Van, for bringing that up. We will eventually get as many of those as we can into that membership site, because we do also want you to review them before you make a purchase. We want to make sure you're buying the right things. I have had someone in the past buy those motions thinking they could put them in for appeal. That's not what that motion package is for. Even though it states it on there on the page before you buy it, they still have done that.
The arguments can be converted to appellate arguments, provided you preserve them for appeal at trial. So they're very useful for informational purposes.
Can you guys hear him okay over there? Because your voice is getting kind of down. So Ron is saying those arguments can be converted into appellate arguments. That is the purpose for them, but you have to preserve them at trial. So you might want to come over here and talk, because I'm not sure if they can hear you if you're commenting. That's great, Kendra, that you're starting the Green Book in the course tonight. I have a study guide in the membership site. If you pull that up, it actually gives you a 30-day schedule, and if you stick to that schedule, you will complete the Protecting Family Rights PFR course and the Green Book in 30 days.
Yeah. So the declaratory judgment motions are written almost in brief form. They're very extensive, and they cover a lot of the rights very thoroughly. We have some new arguments that aren't in those, but you would find those in places like the framing motion. The framing motion is the ideal motion to use if you're early on. But all of those arguments, if you read the declaratory judgment motions, you'll find a better explanation of the arguments, more verbose, more wordy explanation of the arguments. One of the things we've worked on doing is getting this very concise and very compact for the courts. And we're going to start putting some of that stuff in, some of that additional explanation into trial court briefs that would go along with these motions. But even if you're at appeal, learning and reading through and figuring out these arguments can help you, and there are places where you can add them into your appeal.
So Van mentions that amending your original petition and using your wording in your pretrial framing motion in the form of an affidavit to support the custody petition shall pass all threshold of the court as it can be filed and can't be denied. So that's good if that's how it works in your state.
Right. Affidavits are just facts about your case. So they can also strike parts of your affidavit that don't meet that requirement.
Right.
But yes, you should. If you're at a stage where you can, we highly recommend that you put these arguments into your pleadings, into the original document of your case. So modify your petition with these arguments. We have a petition insert up there. We have a couple more in the works. We've done a couple for other individuals on a one-on-one basis. We're working on genericizing those and putting those up there so you can use those.
And I have seen attorneys attach the pretrial framing motion arguments as a supplement to what they have filed, because sometimes there are some instances you don't want to amend what you filed, because from what I've been told, it can start dates, like it can change the dates of things, and sometimes you got to preserve something from a certain date.
Yeah.
And so you got to be cognizant of that. So this particular attorney filed it as a supplement.
Yeah, that's something that's very important. You need to understand what the implications are of amending things and changing things, and it just depends on your state. It depends on where you are. It depends on what words you use in the heading. There's a lot of variables there, and we can't be expert in all 50 states. Right? We have a fair degree of expertise in Texas just because we've gone through it in Texas, each of us, and so much of our work is in Texas. But you've really got to understand the details, the nuances, the specific rules in your state, and that's where having an advisory attorney, even if you can't afford to have them full time, having an attorney that just helps you with the wording and the technicalities of it is very helpful.
Yeah. Okay. And so let's see.
So you hire them a la carte, right? They just review your documents. They give you procedural guidance. Then they just help you with specific questions, but they don't take responsibility for your case. And it'll save you a lot of money, and you still get their benefit.
Right. Okay. So I see one that says they're afraid to file contempt because they say it'll take at least 6 more months and you feel close to getting your child back. That is actually a pretty typical strategy that they use so that you don't enforce. They'll also say sometimes it'll irritate the judge, but the orders are there for a reason, and if you position it properly, I've seen many parents take it successfully. And by the way, that contempt or enforcement can turn your case around. So
certainly turn Sherry's case around 180 degrees.
I don't like to see people blowing that off unless there's some other reason, but just to say that it'll take 6 months, that contempt is separate from your actual trial that's being conducted. Now, of course, if it's a temporary order you're enforcing and they go and they change it, then you don't have contempt anymore. So that could be a problem.
Well, there's technicalities there. The two are independent. You should be able to file contempt without affecting the rest of your proceedings at all.
Right.
Even if they change a temporary order after the fact, you can still enforce contempt against the order as it existed when it was violated. Right, so that contempt doesn't go away just because they changed the order. You're still entitled to what that order said during the period of time when it was enforced.
But not true like in the state of Texas. If they change the temporary orders, they actually take that away. So that's a problem. That's statutory. So it's state dependent. But if you have a final order and there's contempt, let's say interference with possession of the child, that contempt actually doesn't go away from a final order until 6 months after the child turns 18 years old.
Right, and I would argue that
that's in Texas, by the way.
That Texas statute she's referring to is blatantly unconstitutional. Once you have an order, you have a due process right to the results of that order.
Right,
and the state can't remove that. The legislature can't remove that legitimately.
But that brings me to another thing too. You have so many moving pieces here and so many things to focus on, and if your goal is getting your child back in your life, then you focus on the ones that can get your case turned around. So contempt enforcement are serious things to look at, and serious considerations need to be made if you do need to fight for that enforcement, even if a statute is preventing it. That may be a fight you want to take on.
It may not. You got to be very strategic about how you use your limited resources, your limited emotional and psychic energy. This stuff will beat you down like you wouldn't believe. So you've got to be very cautious about how you use up your energies.
Yeah. So let's see. Some of your comments are cute on here about your children. So so Van, you say you have a Stop Abuse campaign. You're telling Robert to look for research on Saunders studies. You said the use of psycholegal testing shall help your case without a child from their parent. Okay, I don't know what the rest of the comment is, but you're talking about psycholegal testing. You want to be careful with studies, testing, things like that. Now, of course, your attorney's going to want to use certain things to your advantage. You need to analyze it, bounce it off of, is it going to contradict your constitutional position? You want to make sure that you make the right choices. You can't contradict that position and then later appeal that if you did contradict it, because the appellate court will anything that they can wiggle out of on your constitutional argument, they will. So if they see that you tried to persuade the court based on studies and testing and all these things that you use that conveyed authority to the court, then they're not going to listen to any of your constitutional arguments.
Now, one of the things I do is in these motions, and most of these motions, there's a statement somewhere that you're asking the court to do these things within the constitutional limitations, and nothing you ask for should be interpreted to be an ask for an unconstitutional action. So I put that in there to defeat what she's talking about, because it's not your job to know every constitutional limitation, it's the court's. And if the court takes an action that violates the Constitution, even though you asked for it, as long as you put the caveat in there that you're not doing that, you can be protected, and that gives you a good case to fight that and say, no, I wasn't asking for a violation of the Constitution. I was asking for my statutory rights to the degree that they comply with the Constitution.
Right, but if you, let's say you want to go and get psychological testing on both you and the other parent because you're trying to prove that the other parent has a personality disorder so that you can show yourself as a somewhat better parent than that one.
Yeah, that you would waive your right on.
Right.
Because you're asking for illegal actions, and you're getting them, and so you can't turn around and say you're protected from what you asked for.
Right. So now if you're using psycholegal testing or social studies or some sort of proof that, let's say you're asking for equal custody, that it's not harmful to the child to have equal custody, then that's fine. You're just using it to support your request to the court. And then if the other side presents studies that counter your studies, then that's just a whole different thing. That's what the lawyers are trained to address. But you would be presenting that in the form that Ron said, which is you're not conceding or asking the court to make these best interest determinations, but you're presenting this information to support your request and to satisfy the prongs in the statute, because that is what the court is requiring. But
for instance, I articulate in some of these motions a way for the court to say it's acting in the best interest of the child and continue to comply with the Constitution. So when you ask, if you're using the motions with that in there and you're saying, I'm asking the court for best interest determination, however, I'm asking for that best interest determination to comply with constitutional mandates. And there is a way to do that. It's called equal custody, equal time, least restrictive means, blah, 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 right? That's all in there. So that's the way the reason I put that in there is to give the court an out, so that the court doesn't have to say best interest is unconstitutional. I'm giving you equal custody, equal time, all equal rights, because that's what's best for the child. And I give them a way to articulate that gives them an out, so that they can continue to do what the statute says and give you your constitutional rights.
Oh, okay. So I see your comments, Van, that you don't want psychological testing, or you don't want a court-appointed psychologist. Okay. So, and then you're using some case law. It's exactly what you want to do. You want to go to case law and see if you can find case law that supports your position. But also, Ron has a GAL motion. Like I said, I just have to edit it, and then we're going to put that up there. We're going to do a webinar on that as well.
The arguments against the GAL are similar to the arguments against the studies, right? It's a First Amendment violation. It's compelled speech. It's a broad exploratory search. It's a seizure in your person. There's a number of things there that are the same principles that are expressed in the GAL. They're just expressed a little bit differently for the GAL than for the GAL than for the exploratory the searches we're talking about, the psychological studies. So we just need to get that put into that language.
They're ordering those psychological studies, Van, and they're not giving you specific reasons, and you haven't been notified of any specific child endangerment or any kind of cause of action that justifies that, and they're not narrowly tailored, and they're just carte blanche saying your life is an open book, then you're going to use some of the broad exploratory search arguments that we use, like Ron said, Fourth Amendment, things like that, things that the courts don't like to apply because they don't want any bright line rules, and they want all that flexibility so they can violate those rights. But you have to close that in. If you have to present those limitations into your court. Now, your court could still decide they want to continue with those violations, and then I actually have worked with parents who, and one in particular, I bring up his story a lot from Florida, where he actually refused. He went to the psychologist's office that the court ordered. Psychologist wouldn't tell him what standards that psychologist used for their study, the study that they were going to do on him. So he walked out, and they enforced the other side, and he went to the hearing and said no. So they basically were trying to hold him in contempt. He actually got out of it using our arguments. He argued to quash that order, stating some of the arguments that I just told you, that it was exploratory search, that he's not going to consent to it. So because he was not consenting, he put the judge on the spot. Remember, we said you want to force the errors. So he put the judge on the spot, and the judge wanted to know the justification for the judge ordering that. And he challenged any statute that the judge was using to make that order as being overbroad and authorizing unconstitutional exploratory searches, and he won. Okay, it was scary to win because the judge was getting pissed off, but he not only won where they canceled the search, but he was also being subjected to supervised visitation with his child, and all in that same day, even though the judge basically huffed and puffed and, did a lot of rolling of the eyes and tried to intimidate. He actually called us later and said he thought he was going to go to jail, but he didn't. And in fact, the judge told him no more supervised visits. Go ahead and get your daughter this weekend. Just shocked the hell out of him. Eventually, this parent did win a summer with the child, but they made the mistake of asking for reunification therapy stuff. We'll go over that in a different webinar because we've gone way over time. You have to learn these things in stages. That's why I'm breaking these down into stages for you, because there's things that come up in each stage. But the point is that when the parent held his ground and pushed the judge to have to justify, because when you guys don't concede and you don't give in, as long as you know you're not giving into the right things, certain things not giving in can hurt you, like not presenting your financial affidavit for a statute that clearly states what it's for. If you're doing it in the right way and you push those judges, they don't want to show their work, as Ron puts it. They don't want to put the reasons that they're asking for this, because they know it's unconstitutional. They know they're wrong about asking for them, and that just showed it, right? But you got to give the judges a way out as well. And so that judge's way out, the solution to that dad was just give me my time back with my child, and that's how he fell into the trap of the reunification thing, because he was trying to give the judge a way out. He didn't bring that up in that hearing, by the way. That came up later in the final. But let us keep teaching you so that you know what to expect, so you can make choices based on having broader information, right? More information. So you're piecing things together, Van, and that's great. So keep applying what you're doing and communicating this with us, and we'll keep trying to walk you through with this education so that you guys don't fall into these pitfalls that they are putting parents into. By the way, they are getting used to some of these arguments, and that's why we evolved them too, which is why you want to stay a member throughout your process, including through your appeal, but even more so throughout your trial process, because as we evolve things and you see these examples come up, you'll be able to evolve what you're doing and not fall into that same trap.
Every time we see a way they cheat out of something, we go in and plug that hole and show how that expose their cheating so that they can't do that. And we're boxing them in, driving them into a place where we want them to be. This is basic military defensive tactics, right? If you set up defenses, you don't put absolute barriers. You set up barbed wire and all these other barriers in a way that channels the attackers right where you want them to go. Then you set a machine gun right there where they wind up being channeled so that you mow them down. That's the idea. This is basic kind of combat tactics. I started out my life at 18 in Marine Corps infantry, so I'm versed in this stuff, right? But it's what you do all throughout life in corporate America and politics everywhere. You channel your attackers where you want them to go so that you can just chop them down. And that's what we're doing with these judges. When we talk about forcing errors, we are forcing them down a path to where they will be checkmated.
And we're doing this peacefully, you guys. So.
Yeah, nobody's talking about shooting any judges.
No.
Right? We're talking about checkmating them. We're talking about putting them into a position where they cannot possibly win and they give up.
He's speaking from things that he relates to and that some of you guys will relate to. And I don't know if you still hear us because the chat disconnected. But I think we're going to end there. It's been 2.5 hours and this, oh, there we go. So that's great. Thank you so much for coming, and we look forward to our next workshop and to all of your feedback. And don't forget about your homework assignments. I'll be looking for those in the email. I'm going to send you out a particular email to use, not the customer service one, so that we don't annoy my customer service. She's always saying, what are all these emails? So I need to use the one that is special to all of you in the membership. Okay, thanks for joining us, and we'll see you guys next time. Bye. I have no idea how to disconnect this. Looks like it's spinning. It says live, but I don't know what to do.
Buttons on the side there.
This one. Share.
Mute microphone.